What's up, everybody? Joey again, Vegas D-Tech. Tonight, man, we're going to be doing Tech Talk number 29. And tonight, man, I got to get down to this situation with Quest. I've had a couple of subscribers comment to me that the information with Quest being sued by First Texas is wrong, and that I just, I'm hearing this over and over again. And after reading through this, and then finally once I got an actual comment from an individual by the name of Malquan Deng, who is supposedly the ex-CEO of Deteknix Quest metal detectors, and he left me a comment. And after reading that, I was like, you know what? I'm tired of MD Hunter. I'm tired of Prospect Detect forums. All these guys here are just saying stuff, but nobody has any factual crap to show what really happened in that court proceeding. I did my own investigations. I pulled the court documents up, and I'm going to show you exactly what I found to find out what is really going on between First Texas and Quest. Was there really a lawsuit? Was the lawsuit dismissed? Why was it dismissed? If that's something that's interesting to you, stay tuned. We'll be right back. Alright guys, we're back again. So what I'm going to do here is I'm going to read this stuff off, and I'm going to put this stuff on the screen where you can actually see exactly what I'm reading. Okay? The first thing that I got here, a subscriber commented to me, and he told me by the name of Yamaha Musicians. He said, actually, they did not win the lawsuit at all. He says, this is pure BS on the part of First Texas. It wasn't them that dismissed the lawsuit. The judge in the trial dismissed it with prejudice, which means that First Texas can't bring the case on again. No copyright infringement was proved at all. Both companies were also ordered to pay their own costs. Now that is pretty amazing there. When a court deems that he is going to dismiss the case with prejudice, see, you can have a case dismissed with and without prejudice, okay? But when a judge dismisses a case with prejudice, that means, you know what, this is baloney. This is just a bunch of shenanigans between both of you guys here. I do not want to ever see this in my courtroom again. First Texas, you are not allowed to bring this lawsuit against this company ever again, because you wasted the whole court's time. After all was said and done, and we came down to a proceedings, you decided you want to dismiss the case and run away. So they said they dismiss it with prejudice. So let's get into this thing here. The next thing that I seen here is I got a comment from the CEO of Quest, which I find very odd that I was able to even get my video, me, little old me here at Vegas D-Tech, was able to get a video out and got into the hands of this ex-CEO, okay? He doesn't work for them anymore, you know what I mean? But nevertheless, I get this comment, and it says right here, thanks for your video for Quest. The fact is, First Texas withdrew the lawsuit because nothing was wrong. Nothing wrong was found after lawyers compared code to code. And he says to stay tuned for the new Quest products in 2022. Short, sweet, to the point, didn't drag it on. That came right there from Malquan Deng. Alright? So let's get into the actual court documents here, okay? So the first thing that I'm going to show you here is the motions. Here's the court header. I got this from Court Listener. Court Listener right here has all the dockets on file, and it shows that there's 66 dockets, or actually one case with 66 docket entries. And as you can see here, First Texas Products LLC versus Deteknix Incorporated, aka Quest. Okay, so let's jump in here to the first docket that we see. Here it is, First Texas Products, LLC, and it shows right here that it was the first initial document complaint was filed by First Texas, $400. It says date filed August 30th, 2016, and it was terminated June 28th, 2017. So basically this thing ran for almost 1 year. Almost 1 year before it was finally adjudicated and finished with, okay? So let's get down here to the very first couple of documents here. Alright, so after First Texas decides to file the suit, It goes all the way down here, back and forth for a year, and they get down to document 59. And here's where Quest finally decides they're going to file a motion for non-infringement, because both sides had lawyers go through each line of code with software writers, whatever, and they went through code for code for code. And it was deemed right then that the codes did not look alike. They were not alike, all right? So, after all this crap of being drugged through court, Deteknix finally puts in a motion saying, hey, you know what? Here's all of the proof. Here is all the exhibits showing that there is nothing wrong with our code. Our code is nothing like what First Texas claims they own. All right? Second statement, number 60. Statement of unconverted facts and conclusions of law. Judgment as to non-infringement filed by defendants Mao Quan Dang of Deteknix. So basically now in document 60, they're filing another motion saying, hey, where's the facts at? Are you guys going to show us where we actually infringed on you? I have a motion right here. I'm demanding that you show me where I infringed on your product. Crickets. Nothing from First Texas. Just nothing. All right? So then we go, so now after waiting again, here comes the next one. Notion of motion and motion to strike. To strike now. Now Deteknix is getting pissed. We're just like, you drug us through court, you slandered us, you said we stole your code, we just had our attorneys look through this stuff with software experts. I have all the proof here showing that they're not alike. I asked you to submit your proof that we actually stole your product, and crickets. So now I am submitting a motion to strike with, it says right here, report of Zidun Jawaldi and preclude expert testimony filed. Expert testimony. That wouldn't be Mao Quan Dang. That would be this person, Zidun Jawaldi, who is probably a software code expert here that's going to testify and show the proof that there is nothing the same with the lines of code. All right. So then when we go down here, finally we go to 62. Stipulation to dismiss case filed by plaintiff First Deteknix. Oh, now we find First Deteknix jumps back. They're being forced to ask him, what are we doing? Where's the proof? I want to see where I actually stole your stuff. And here is document number 62 showing stipulation to dismiss case pursuant to FRCP 41 filed by plaintiff First Deteknix Products Corp. So what does that mean? That means First Deteknix is saying, oh, we want to dismiss all charges. We want to dismiss the case. Okay? So you take this company here, man, you allege that they stole your software, file a suit against them, put them through a year of this crap here going to court, and then you finally get to this point where they compare the software and see that the software code did not even look alike. No case. And now you want to drop the case. All right? Number 4, 64. Order on stipulated consent judgment by judge. Stipulated consent is hereby ordered and adjudged that defendant Deteknix agrees not to infringe on any of the plaintiff's copyrights to software codes as alleged. Okay? So the judge adjudicated saying that he was going to put this stipulation that Deteknix does not infringe on any patents that they were alleged to have done. And Deteknix is like, we never did anything. But yeah, of course, we'll consent to that because we never did anything anyways. And the judge is just saying, okay, just agree that you won't actually copyright any of their stuff. They're like, okay, but we didn't do anything anyways. Okay? And then it goes down here to the final one was just court number, document number 65. It says order on stipulation of dismissal by Judge Manuel L. Real. Pursuant to the stipulation, it is hereby ordered that the plaintiff's cause of action against Mao Quan Dang are hereby dismissed with prejudice. What does with prejudice mean? Here it is. With prejudice means that you can no longer bring this crap back up again. You know what I mean? This is foolish. It should have never happened. You wasted the court's time. You wasted the court's money. Okay? And so again down here where it says where it's dismissed with prejudice, defendant's causes of action against plaintiffs are hereby dismissed with prejudice, and the parties are to bear their own costs and expenses. Case terminated. Made JS6. Alright guys, here it is, dude, in black and white. This is what happened in court. So guys, I swear to you, I've used this Quest product, and people have asked me, Joey, man, I seen that Quest Q40 that you have there. Do you recommend me using this? Would you recommend this detector? And you know what, guys? I have a responsibility. I don't want to go out there and tell somebody to go and get this type of situation. And the only reason why so many detectorists on these forums said that they were on the fence about buying the product anyways is because of the lawsuit alleging that they stole their software. Look, anybody can allegedly accuse you of doing something wrong. You could be alleged a pedophile, you're a teacher, you're being accused of something like that. Some girl at work could allege that you're sexually harassing her and your job is at stake. Man, anybody could just point the finger and accuse you of something. But they also have to prove that in the court of law. And this went to court, it wasted everybody's time, and when it came down to it that the source codes and the software codes were viewed code for code by software experts, it was proved that Quest did nothing wrong. It's right there in black and white. I showed you the court documents right there. And at the very end, First Texas said that they wanted to drop the case. The judge went ahead and said this is a waste of time. You guys wasted the court's time to come all this way and to finally drop the case. So that warrant of Deteknix, Quest stealing somebody's software, that was wrong. It was not right. First Texas did not win. They dropped the case when it was proven that the source codes were not the same. The software was different. Alright guys, and that's all I want to say, man. I don't want to get into it anymore about who said what. Many people say, like I said, they're on the fence, they like the product, but they said, I don't know if I would ever buy something from somebody who stole some software in the beginning. They were alleged, and it was proven here that they did not do that. Alright guys, so you know what? Tomorrow's my day off. I'm going to go out here with this machine. I bought this machine once before, and I am actually astounded at the build quality of this machine, at the way it sounds and at the way it works, that not more people have bought into this, and only because they have a bad taste in their mouth that this company did something in the beginning, which was thrown out in court because it was proven that they did not do anything. Guys, that's it. Thank you so much, man, for tuning in again to Tech Talk number 29. I appreciate your guys' time in listening to this. It just burned me to death, man, because I'm getting messages from subscribers saying that's wrong, and then I actually get a comment from Malquan Dang, who was the CEO of Quest, telling me that was wrong, and then I have to go and research this stuff myself to get down to the court documents and read verbiage, and I showed you exactly what I had. So guys, there it is there, man. This is Tech Talk. This is what we do. This is Vegas D-Tech. We get down to the bottom of it. I don't give you guys nonsense. I research this stuff and I give you true facts, okay? Because like I said, I feel that I have a responsibility here. I have a platform and I want to give you guys the correct information before I ever give a review or anything like this. We both have the facts now. Right on, right on. Joey Vegas D-Tech, guys. Thank you again. I'll see you guys in my next video. You guys have a good one.